Hi everyone, and welcome to our webinar on latest amendments under legal metrology law and general compliances therein. Uh, Legal metrology law in itself is a very interesting law. I've had quite a love with this law. So I often joke with my friends that they go to malls for shopping, wherein I go to the mall to check label of the products. This law, recently there have been many amendments which have been issued under this law, which were much required and has kept us busy. Further, the department is also strengthening its bench strength to improve the compliance across the country. And we can expect that the compliances, or let us say the enforcement from the law, would be much stringent in future. Therefore, the amendments which are coming have become quite important. In today's webinar, we'll be discussing the amendments which have been proposed in past some time, the compliances which are related with this law, the way forward, and in the end, we'll take question and answer from the participants. So amendments will be taken by my colleague Ashutosh. He has a rich experience in legal metrology law, and in fact, even has written a book on the same. He briefly worked with the legal metrology department. So over to you, Ashutosh, to take this part.
Thank you, Deepak. A very good afternoon to everyone. I'll straight away move to the amendments part. So as you may all be aware, in the past 1 year, there have been many amendments relating to legal metrology. And as far as the declarations part is concerned, the first part deals with declaration amendments, which came in November 2021. Post that, there have been many amendments to since the implementation date starting with these amendments was April 1, 2022. Thereafter, the date was extended to October 1, 2022. And lately, it has been extended further. And now the implementation date is December 1, 2022. And along with this extension, there were some amendments to these declarations as well, providing clarity to the issues that were initially raised in these amendments. Apart from that, there has been one general amendment relating to nomination, which decides the liability or under when a violation is done under legal metrology. And lastly, some industry-specific amendments that took place. Now, I'll start with the declaration amendments first. So the first requirement that came in November 2021 was relating to unit sale price, which was not a requirement before these amendment came. The only requirement was mentioning of retail sale price. Now, after these amendment, what is said is that the unit sale price up to nearest 2 decimal places needs to be mentioned on package containing identical items. A new amendment that took place in this unit sale price requirement was mentioning up to 2 decimal places, because before it was not clarified where how many decimal places need to be mentioned. So there's no requirement to round to the nearest rupee or 50 paise like in retail sale price before, but it's just 2 decimal places that you need to do. Apart from the specific the specific formats were initially provided that for example, if you look at these 3 formats, whatever quantity you are declaring in your MRP label, then accordingly the unit sale price, for example, if something is being declared in grams, then the price per gram. If something is more than 1 kg or more than 1 kg, then the unit sale price per kilogram. And if something is being declared by number, then unit sale price per number has to be given. One thing to note is that in this case, once this new amendment came, earlier the specific formats were provided, which we recommend should be followed by declaring the unit sale price. However, the only requirement from the LMPC rules is that the unit sale price should be given. Now, another issue that arose in these declarations was whether if there's a single unit, then whether USP needs to be mentioned or not. So there has been a welcome amendment in these regards, which says that there's no requirement to declare unit sale price in case of a single unit. So the law says that if the unit sale price and retail sale price are same, then in that case, there's no requirement to mention unit sale price. Another welcome amendment that is being proposed by the department is exemption in relation to various types of kits. So they have defined three types of packages. One is combination, the other is group package, and the third one is multi-piece package. So how they have defined these packages is that combination package, for example, if you are selling a cutlery set containing different type of commodities, for example, a fork, a spoon, a plate, then those type of packages would fall under the definition of combination package. For now, the next example is, for example, if you're selling a packet of biscuits containing different quantities or different brands of biscuits, then that would fall under group package. And the third category is that the items are similar. For example, 5 bars of soaps, but the quantity is similar. So 5 grams of soap or 20 gram each. These will fall under the definition of multi-piece package. In all these cases, what the government has proposed is that the requirement of unit sale price would not be there on the outer package, that is the outer package of the kit that is required. Once again, I would like to reiterate that the amendments that are already there, not the proposed amendments, are to be effective from December 1, 2022. The government has given an option that you may start following these laws from now itself. So there's no issue in that. But you need to keep in mind, if you are following these new rules, then you need to ensure that all the amendments are followed, and you cannot pick and choose some amendments. So for example, we'll be dealing with an amendment relating to standard packages later in this slide. So if the government has removed the requirement of standard packages, then it is automatically understood that you need to give unit sale price also. So you cannot pick and choose that you would not be selling in standard packages but would not get the unit sale price. So to avoid any issue, it is recommended that you are following the amendments from now itself, then follow all the amendments. Otherwise, the effective date of these amendments is December 1, 2022 only.
So just a couple of points here, and Ashutosh very clearly explained the amendments in unit sale price. Just one point to add here, and a very positive point from government side. You'll note that Ashutosh in several places mentioned that initially they mentioned that you have to provide unit sale price. And then they provided or substituted multiple clarifications that in case of single unit, that is not required because of space, and there's no logic there also. Then secondly, they provided or clarified the decimal places which needs to be there, etc. And now they have again proposed an amendment for combination package, group package, and multiple piece package. What these indicate is that with these amendments, the government is not keeping a closed mind that, okay, this amendment has been prescribed and it would not be changed. As and when the representations have been made by the industry that these are the issues that they face in these amendments, they have modified the amendment to suit or include a practical angle therein, which again is very appreciable from government side. A second important point in this is, which Ashutosh mentioned, that while the effective date is December 1, companies may choose an earlier date also. And why this is very important is that because usually what happens is there is a quantity of packaging which is pre-printed or available with the manufacturers or packers. That cannot be changed overnight. So on 30th November, you cannot decide from tomorrow the entire packing needs to be changed. So they have effectively given you a timeline that, okay, let us say you take a cutoff date of 10th November, 15th November, that post that date, new packing can be implemented. So the earlier packages can be exhausted. There's a time limit which has been given to you, and then you can have new packages or new labels with these amendments. So this would give you an easy transition and would avoid issues of, let us say, accumulated packing material which you had, and give you an option of smooth transition to these new rules. Yes, Ashutosh.
Okay. So moving on to the next amendment that was relating to quantity. So earlier what used to happen was that commodities that are sold in pairs or set, for example, a shoe being sold in a pair. So the requirement of LMPC rules was that you have to declare a quantity by number either by N or U. But for example, shoes that are sold in pairs, you cannot, the law did not allow using of the words pairs or sets. Now, this is a very good amendment which says that new units of measurement such as set, pair, piece, or any other similar word can be used to declare such quantities. So earlier, what used to happen that if you need to declare the quantity of shoes as 1N, then as an additional declaration, pair word could have been used. But now declaring the unit is as 1N is not required, and you can directly write one pair of shoes as the quantity. So the option to use N or U has been withdrawn. You can use any word as mentioned above along with N or U or numbers or units in full form to declare the quantity of products. Now, another amendment that has been proposed, that is a very interesting amendment relating to quantity. So for example, if you're selling a product by some USP, so by USP, I mean, for example, if there's a sanitizer, which has a high amount of content of alcohol, which kills bacteria, or if there's a shampoo or conditioner, which contains onion or coconut, and you are selling this product saying that onion or coconut is the USP of this product, then in such cases, the government has proposed that these primary constituents need to be declared along with the brand name of the product on the front of the package. So what will need to be done is that, for example, if XYZ is a product, it's a sanitizer which contains 70% alcohol, then along with the name of XYZ on the front of the package, you'll have to mention the quantity and percentage of alcohol on the product. Now, some issues that may arise in this amendment is that, first of all, what is a prime constituent has not been defined by the department yet. So, for example, even what percentage of product would make the constituent a primary constituent has not been defined. Along with that, if you look at the proposal, they have mentioned principal display panel as the place where these declarations need to be made. But when proposing the provision, they have said that it needs to be mentioned on the front of package, which creates a confusion in this regard. So although the date for public consultation on this is over, but you can always consider filing a representation in this regard, that if this amendment needs to be brought, then more clarity is needed in this provision.
Right. So again, I think a very important proposed amendment, because in many of the products, there is one basic criteria which is focused on, or a USP to distinguish it. So that now needs to be declared in this. So this amendment is one to be looked forward to. And what it is, it did not came recently, but it has been there for some time. So I think this is something which the industry should know and should file representations in this case. Another important point in the change in quantity is that the legal metrology professionals, or let us say the industry, they have ingrained the usage of the words N or U. So very candidly, when I entered, I was surprised that why do you need to mention one N and one U instead of a smaller or shorter form or a complete form. But that is how the law was. And that mindset now needs to change back. And because it is so ingrained, it may take time. So we often get a lot of questions that even after the amendments, can the quantity 1N be continued? Because it also has an additional benefit of saving space. However, because the provision has been removed, we would not suggest that. So we suggest that even at the expense of space, or let us say some additional cost of printing, the entire declarations of one number and one unit are used. So this is, I'll say, one of the important change in these amendments, which would require mindset change also, that while mentioning declarations, write the complete declaration, and the short forms would not be permitted.
Okay. And one more thing I'd like to add on this, that unlike food or drugs and cosmetics laws, where there's a particular requirement to mention list of ingredients in the product, there's no such requirement in a legal metrology law to mention the list of ingredients. So that would be another issue in this proposed amendment that needs to be taken care of. Now, moving to the next amendment, that is relating to month and year of marking. So in this regard, earlier the option that was provided was that in case of manufactured, imported or packed product, you'll need to accordingly mention the month and year of manufacture, packing or import. This option was removed by the 2021 amendment, and now the amendment says that in all packages, month and year of manufacturing needs to be mentioned, which practically creates a problem for importers and traders who are the brand owners of the product, because it's very difficult to determine, especially in case of imported products, what the actual month and year of manufacture is. Now, in this regard, a very welcome amendment has been proposed by the government as well, which will reinstate this option. So, but for now, the option is that you need to declare month and year of manufacture from December 1, 2022. But it is likely to happen, since this amendment has been proposed, that this option would be reinstated, and the practical difficulty that would have been there may or would finally be removed by the government in this regard.
This is another classic example, as you were mentioning earlier, that government is very open for suggestions. So on this point also, the amendment was made. The industry made representation vis-a-vis the practical difficulties, and we see that now they have proposed an amendment back to reinstate this. So again, a very welcome move.
Moving on to the next amendment, that is format of declaration of MRP on the products. So what used to happen that in particular cases, for example, in international flights, if a water bottle is being sold, since it's an international flight, so people used to prefer that the MRP be declared in some other currency apart from Indian currency. Now the law has clearly declared, and along with that, there was a requirement to mention the MRP in particular format, which was given in the illustrations of the rules itself. Now the amendment proposes that the MRP only needs to ensure that the retail sale price inclusive of all taxes and in Indian currency needs to be mentioned on the products. There's no specific requirement to follow a particular format. You can use the old illustrations as well, and that would be a recommended way to going forward, because that is something that is tried and tested by the department, so it would not ensure any issue. But in any case, since it allows some leverage to the industries to mention the retail sale price inclusive of all taxes and Indian currencies, and the condition of rounding off to the nearest paisa or 50 rupee or paisa or 50 paisa has been removed. So now it's an option up to the concerned business in what format they need to declare, as long as all the information that is required is provided relating to MRP. That would not create an issue. So for examples, these three are the methods that can be now used to declare the MRP. So you can write MRP in small form inclusive of all taxes, INR 250, instead of the rupee symbol or rupees in short form. You can mention it in full form, and you can use any arrangement. You can mention MRP first, inclusive of all taxes in between, or inclusive of all taxes after it. Again, the implementation of date of this amendment is December 1, 2022. The next amendment was relating to standard packages. So what the law provided under Rule 5 and second schedule was that certain commodities like tea, coffee, pulses, or in certain cases certain cosmetic products need to be sold in particular standard packages only. So for example, tea may be sold only in packets of 50 gram, 100 gram, and so on. This requirement has now been removed, that you do not need to mention or sell your products in standard form, and accordingly the second schedule which provided for these specific commodities has also been removed. There was a requirement to declare that in case if you're not selling non-standard packages, then in that case you need to give a particular declaration in that regard. So this requirement will also be removed from December 1, 2022. This is in line with the requirement of unit sale price, because now since the law will require mentioning of the unit sale price, so standard packages may not be required, because the purpose of doing it in standard packages was that the price per gram per unit needs to be mentioned. So this is in line with this amendment. Now, moving on, before moving on to the next amendment, we'll take a look at what these amendments entail in the old and new labels. So for example, in the old labels, the mandatory declarations that was required were name and address, name of product, quantity, packing month and year, or manufacturing month and year, or import month and year, MRP inclusive of all taxes, and the customer care details. Now, after the amended rules would come into force, the requirement of name and address remains unchanged. Name of product remains unchanged. Quantity can now be declared in full in numbers or pairs or sets, etc. packing month and year and import month and year are not allowed till the proposed amendment is put into force. So you'll have to mention compulsorily manufacturing month and year. MRP, any format can be used now. The MRP should be mentioned inclusive of all taxes in Indian currency. That is the only requirement. And along with that, you need to mention the USP as well. You can, for USP, there's a particular amendment that says that up to 2 decimal places you need to provide. In case of MRP, if you wish, you can use up to 2 decimal places or not. That is up to, that is a commercial call that you will need to take. And the customer care details need this remain the same. Now, we did a poll on some specific amendments, and there has been an amendment relating to nomination of persons. So the shortly put, it says that the now persons other than directors can be allowed to be nominated for a violation under legal metrology. So our poll question was whether allowing nomination of persons other than director will be beneficial for business. So the results of the poll were that 68% of the audience felt that yes, it would be beneficial. 29% felt that no, it would not be beneficial, and 4% are unsure. Now we'll take a look at what actually the amendment is. Now, one basic understanding that we need to have about liability under legal metrology is that the legal metrology covers not only the packaged commodity labeling activities and rules, it also covers other factors such as governing weights and measures, and along with that, a uniform application of the legal metrology is done on advertisements, or in case of any document or invoices, uniform standards need to be followed. So the liability part comes for all of these violations and not particularly to the LMPC rules. So what section 49 2 of LM Act poses this liability on two people. So one is the company itself, and the other was that in case a person is nominated, then the person who is responsible for conduct of business, which is considered as a director of the company, and if also provided an option of nomination of directors, which says that for example, if a company has 5 to 6 directors, you can nominate one single director for violation of the particular legal metrology violations. You can nominate that particular director, and the format was prescribed in the legal metrology general rules for this. And this is important because the liability under legal metrology is a criminal liability. So in case of after second or subsequent violation, there may be an imprisonment for the person who is responsible for this. Now, the amendment has proposed that nominated person who are in charge or responsible for establishment, they can also be nominated for these activities apart from the director. So the liability would now shift from the directors to the persons who are nominated, who are responsible in charge of the business of the company. So ideally, this amendment should have been brought under section 49 of LM Act. But for now, section 49 remains unchanged. The amendment that has been brought is in rule 29 of general rules, which was the rule for providing the format of nomination. But as we have reiterated before, the government has been very open in making amendments in legal metrology, and to allow a breathing space for the businesses as well as the consumers. So this being a beneficial amendment, it is unlikely to be challenged on this ground of validity of the amendment. So because of this amendment, now branch head or a unit head or operations may be nominated for violation of the Legal Metrology Act. And although the amendment has been prescribed specifically saying that it is if a company has different establishment or branches, but looking at the intention and a provision of the General Clauses Act which says singular includes plural as well, and vice versa. For single units as well, persons other than directors can be nominated going forward.
So just taking a second here, and a very, very important amendment. We'll also discuss in the procedure part. One, many people are not aware that there is a concept of nomination under legal metrology. So if let us say there are 5 directors of the company and the company itself, so 6 people were responsible, company being the artificial person and each of the 5 directors. So firstly, even till now, there was an option to appoint one director who used to take care of, who used to take responsibility of legal metrology, so that the, I'll say the impact of any non-compliance, if any, is also gets reduced. Now the provision has further been widened, and in that context, that is what the poll also show. It is a very welcome move in that context that they have widened this provision, that logically the director is not taking care in day-to-day affairs. If let us say a senior officer, or let us say a branch manager who deals with these products on a day-to-day basis, if he's dealing with those products, he be given that option to he be given that option. So in that context, again, a very important amendment vis-a-vis nomination which has been there, which also has an impact on the regular compliances which the company needs to take.
Another thing that needs to be kept in mind is that the nomination part can be done online or offline as well, because the rules still provide for a format of application. So a manual application can be filed with the department as well. Along with that, there are specific online facilities in particular states as well as in the center also. Now, coming to product specific amendments. Now we'll first of all deal with the requirement of that a new requirement that has come for. It's not a mandatory requirement, but an option that has been given to the electronic products industries. So products like television or laptops or camera, which are fall under the category of electronic products, have the option to declare some of the declarations in through QR codes. And this implementation has been done from July 15 for a period of 1 year. This needs to be mandatorily followed if the option of mentioning the declarations, those specific declarations, is taken to mention through QR codes. Now, what are the declarations that can be given to the QR codes are: address of manufacturer, packer, or importer, common and generic name of commodity in case of a single product, name and quantity of each product in case of kits, size and dimension of the product, and in case of consumer care details, only the name and address of person or office who can be contacted in case of consumer complaints. These can be given through the QR codes. Along with that, if you're giving these declarations in through QR code, so particularly in case of address of manufacturer, the name of manufacturer, packer, or importer needs to be given on the label only. In case of consumer care details, telephone number and email address of person who can be contacted needs to be given on the label only. And a uniform disclaimer that needs to be given is to that the particular declarations that you are giving through QR codes can be scanned through those QR codes. A disclaimer in this regards needs to be given. And this does not have to be a general disclaimer that for further details scan the QR code. You have to particularly mention the details that you are giving on the QR code. So for example, if you are giving address of manufacturer and a common and generic name through QR code, in the disclaimer, you need to mention that the address of manufacturer and the common name of the commodity can be scanned through the QR code. So this is a very good amendment which allows spacing issues to be resolved in case of labels of electronic products. The next amendment that we'll be dealing is with respect to legal loose commodities, declaration on loose commodity. So this has been a legacy issue in legal metrology rules, along with in the erstwhile regime of standard weights and measures as to what actually comprises or a pre-packaged commodity. And in those cases, there has been a lot of issue relating to products which are put up for testing and verification at the point of sale. So particularly relating to loose garments, there was a judgment of Karnataka High Court, Kandakuri Garments, which says that even if these products are put outside for testing by the customer, but once they are put in package before selling it to the consumer, LMPC declarations need to be followed. So particularly for loose garments, what the government has done is that they have given an exemption to garment or hosiery sold in loose or open form. But however, certain declarations still need to be mentioned, which are name and address of manufacturer, importer, brand owner or marketer, consumer care number and email ID, size with international standards along with metric units such as meter, centimeter, and the MRP in Indian currency. This provision is applicable from January 1, 2023. So yes, exemption has been given to garments sold in loose form, where consumer can inspect these products, but certain declarations still need to be mentioned. Line with this amendments, a new amendment has been proposed. Firstly, relating to loose garments. So right now, the requirements say that the international sizes such as M, XL, etc., has to be given with the metric units. Even the requirement of law, even if we do not consider this provision, the units of quantity always have to be given in metric units only, such as meter and centimeter. Declaring it in international indicators is an additional requirement that is given in the proposed rules. Now, what has been done is that these international indicators are not mandatory, and it is an option to declare the quantity in case of loose garments in international sizes such as MXL. Apart from that, for e-commerce entities particularly, an amendment has been proposed that whatever loose commodities are being sold on the e-commerce platform, they are exempted from declaration of LMPC rules, but these loose commodities should contain some particular declarations, which are name and address, consumer care number and email ID, MRP in Indian currency, and the quantity of the product. So even if sold in loose commodity on e-commerce, this will be an additional requirement that these loose commodity needs to have these declarations as well.
So just one point here in this, and the amendments have been explained quite clearly. So if you see, there's a one conceptual question which has come in this is, with this amendments, the department is effectively saying that even if you are selling the goods in loose, that is, they are not packaged, you need to give these declarations. But if you see the entire premise of legal metrology law, it starts on the fact that they would be applicable only if goods are sold in packaged commodities. So this is one gap. There was in fact, this issue was pending before the larger bench of Supreme Court till recently. However, the Supreme Court on a technical point dismissed this issue. So now this issue has remained open, that why does a manufacturer, or let us say a brand owner, needs to provide these details if the goods are in loose only? And that would be applicable not only for garments, but for all the products. But presently, till the time of sufficient clarification to that effect comes, the brand owners, in order to avoid disputes, to declare the MRP labels. But yes, this is something which the department should, because they are considering so many clarification, representations, etc. This is also something which they should clearly specify vis-a-vis the law provisions, or let us say amending those provisions if required. But this is one open point here.
So the last industry specific amendment that I'm going to talk about is relating to edible oils. So the law currently says that Schedule 4 read with Rule 12 provides that in case of certain commodities, you have an option, you have to declare the quantity of the product in the particular format that is being provided. In Schedule 4, in case of edible oils, it says that you have to mention the quantity either in mass or in volume. Along with that, Rule 5, which talks about standard packages, it says that in case of edible oils, if you are declaring the quantity in volume, then you have to mandatorily declare it in by mass also, by weight also. So what used to happen is that
I think we can. So just I think we can wrap this also, because not many edible oil participants here. But the idea is that they earlier mentioned that you need not mention temperature. However, now they have again proposed the fact that you need to mention both the weight and the volume at normal temperature, because one schedule was removed. So I think we can conclude it here. And for any specific queries on edible oil amendments, we'll be happy to take separately. So now just quickly covering what the compliances are existing and what nomination amendments would have an impact on this. So we have dealt number one, requirement of registration, and what are the options? Do you have an option to take a central amendment or a state specific amendment? A nomination of director or other officers, whether all declarations can come in one place or in a scattered manner. This is a question which we have been hearing many of the clients ask, so we have covered this. And timing of a fixation of MRP labels. So we ran a poll vis-a-vis, we asked a question, what do you think is a requirement of obtaining registration, whether you have obtained central, state, or not sure even if registered? One surprising point is 18% of the taxpayers or packers, brand owners are not sure whether they are registered. And this, I'd suggest that those taxpayers should have a clarity on that, and that registration certificate should be readily available with you. Now, vis-a-vis the other participants have an equal split. Many have obtained central registration, equal number, almost equal number have obtained state registration also. So in this, if you see on whom the requirement is of registration, it is on all packers, importers who sell, distribute, deliver these quantities. Surprisingly, the requirement is not on manufacturer, but on packer. But what we usually suggest is that if, let us say, the manufacturer and packer are different, let us say in many these brand owners, they get the goods manufactured from some other place and then they pre-pack it. So we usually suggest that in order to avoid any dispute, let both the premises or both the parties be registered, because one is the packer, which is specifically mentioned in this, and one is a brand owner who has taken upon himself on all the compliances. So in this case, practically we suggest both of them to get registered if that be the case. Another second very important point here is that they have permitted a registration of a shorter address. So if you see your entire mailing address, that might be very, I'll say very big. There might be khasra number, tehsil, etc. Many details are there. We have seen in some cases. So the law permits for you that at the time of registration, you can register a shorter address. And that gets useful. We'll be discussing in the next slides vis-a-vis the spacing requirement. So that option is also available. The amendment in registration certificate is permissible. So if, let us say, any packing unit is added or any factory is added, that should be there, or any new category of products is added, this amendment should be done. There is no requirement. If, let us say, you are registered under the erstwhile law and there are no amendments, you need not get a fresh registration under this law. Now, answering the question where you should get registered, center or state, the law does not have any bar. You can register in either of the authorities. Many companies, they attempt that, because if, let us say, the units are spread across different states, in order to have a single registration, they attempt or they try that a central registration is granted. However, we have seen some reluctance from the central authorities to grant such registration. But yes, under law, it is permitted, and we have seen sometimes such registrations also being granted. Moving on to the next topic, and another poll which we ran, which again we have felt is a quite common issue, spacing issue. So many companies have this issue that there is no sufficient space on the size. So can we print on two sides? The product is too small. What should be the height of the characters, etc. Regarding this, we just wish to clarify. Firstly, there is no option to have declaration on two sides. So all the declarations should come on one side, which is referred to as principal display panel in the legal metrology law. So in case of, let us say, rectangular packages, that can be any one side, not necessarily the largest side, but any one side. And in case of cylindrical packages, that is considered as 40% of the surface area. So that is why you see on the bottles, it is there on the bottle itself, it is printed. Second, the height, the minimum height of the character has also been prescribed. So sometimes what you can also do is, depending upon if, let us say, you have different product sizes, you can also decide to have some slab of sizes, which of course needs to be legible. But yes, it is not that on a very big package, you have a very small font size or vice versa. So both of them can also be an answer to the spacing requirements which companies face. Lastly, there's also an option or a question which helps to save spaces, and for that matter, even cost. On the label, whether you need to have the law permits, you can have a pre-printed information, you can have online printed, you can have a pre-printed information or online printing. So a combination of pre-printed information as well as, you can say, online printing, or the law permits label also, that can also be used to save some space on the label so that all the declarations can be provided. And sometimes, because of pre-printing, it also helps you to, let us say, act in a cost-saving manner, that most of the information if pre-printed becomes less costly. And let us say the date of manufacture, packing, or MRP comes to online printing, that helps you to, that becomes expensive. So these multiple options are also permitted. Notably, an additional label. So the product can have one label, yes, to declare all the informations, or let us say with pre-printed information, part of the information. But An additional label is not allowed. So sometimes clients prefer to have information of 2 labels that is not permitted. You can do it only for declared in MRP, the decrease in MRP. We'll also like to highlight that increase in MRP is not permitted under legal metrology law, except for certain exceptions, let us say change in tax rates, etc., for which you have to give information. But yes, if you are to decrease MRP, that can be done with an additional label. Sorry. Another important question as we were discussing was in case of imports, when do you affix MRP? So in one of the compliances is at the time of declaration of MRP in such cases. So for imported goods, it is very relevant that the law prescribes that before custom clearance, you need to provide this. Sorry. So you need to provide this MRP. So usually what happens is you either ask the foreign supplier that the goods have an MRP affixed, so that when the goods are cleared from customs, there's already an MRP affixation there. Because at the custom clearance time, you cannot affix all the MRP. Or let us say if it is not possible to ask the foreign supplier. In such cases, what happens is the importers take bonded warehouse, wherein the MRP can be affixed while being kept in the bonded warehouse before custom clearance. And from bonded warehouse, such custom clearance happens. Vis-a-vis the domestic products, they are to be affixed before packing or pre-clearance. Here again, a dispute sometimes comes is whether at the time of storing tagged goods, whether you need to have an MRP or not. There are different views vis-a-vis the department or what the practical constraints dictate in this case. But reading the law in completeness, one can say that only before packing such MRP needs to be declared. So again, the entire issue vis-a-vis the time of affixing MRP also has finer points. So in this regard. Now, just briefly covering the way forward before we take your questions. So herein we have only covered the amendments, but the basic law of MRP also, while it has been constant for a long time, has a lot of finer points, jurisprudence arising on the issue, or let us say some interpretational issues or some strategic planning which may be required. So in this case, we firstly suggest that the existing models be, let us say, analyzed so that there is no non-compliance. And this amendment can be taken an opportunity to ensure that even the existing compliances were there. Secondly, these changes on business, be these legal changes or let us say the business changes itself, let us say a merger, opening of a new unit, etc., they're timely assessed so that they can be implemented and no stock is at a danger of being seized or being a non-compliant stock. Secondly, for these amendments, as we talked, so many amendments have come, many are proposed also. So there should be a proper transition plan for these implementation of these amendments. Otherwise, a lot of confusion we have seen happening vis-a-vis the packing paper being wasted or the time of when it should be implemented, etc. So this is another very important point. Requirement of registration and nomination. We saw that registration, some people were not very sure whether they are registered or not. And which we understand because it is not something which enters the mainstream, so sometimes this gets missed. But yes, there is a requirement of registration and there is an option of nomination, which should both be exercised or opted by the taxpayers. Lastly, yes, internal training to the teams is very important. So on day-to-day basis, any misses vis-a-vis these law does not happen. And as Ashutosh mentioned, the penalties or let us say the implications, it directly has criminal implications on the directors or the nominated person. So this becomes very important that the internal teams are also trained vis-a-vis these rules. And of course, we suggest that in case there's any doubt or later any confusion, a professional support on the requisite areas we sought. Thank you, everyone. Thank you for attending so attentively. So any questions which are left, you can please write to us. The mail ID is given and we'll be happy to answer. Thank you, everyone. Thank you, Ashutosh, for this session.
Thank you so much.